at reciprocity. So I have clients actually in both states, New York and Georgia, and I do these presentations and binders every other month where I come in and talk about some legal issues for artists. And it's been really great to sort of partner with the Black Book conversations to even reach more of you, because I know a lot of artists always have questions about how do I protect, right, what I have with so much love produced and created, right? And then how do I get it ready to sell, as well as some of the other questions that we'll be talking about today. And today we're going to focus in on copyrights and trademarks as it relates to your artwork. Now I know the handouts look very small, and we're going to say that that's done on purpose so that you actually pay attention to me as we talk, and you can just have that sort of as reference. But if you want it a little bit larger, Danielle will have the handouts on the website when we get the recordings up there, and then you can pull it down from there, okay? Yes, please. And also, this is my photo. I am sticking by it. Anybody who asks me for a headshot, this is what I give them. Make sure you get a little postcard and you can have my contact information. No problem. I'm going to move these over here, okay? And as well as please sign in. Thank you. So how many of you are here for the first time? Okay, is this your first time in the Black Book conversation? First time listening to me?
Yes.
Okay. Well, hopefully I won't scare you as I didn't scare the others, okay? Law can be very scary, I know. So I'm going to begin, first of all, with saying a disclaimer, because I am a lawyer, right? This is for educational purposes only. It's not to be construed as legal advice. Each of you may have a particular issue or question, and we're going to really be dealing with some generalities. At the end, though, we will have some time for questions and answers, okay? Also, you're going to notice in your handout, I use some images so that I can illustrate some points, and those I am using under the fair use exception of our Copyright Act, and we're going to get into what that is. So, first of all, let me get a sense of who's here in the room. I was able to talk to a few of you, not to everybody. How many painters do we have? Okay, sculptors. Mixed media. Graphic designers. Illustrators. Any animators? Okay. Let's see, did I miss anybody? Video performance. Any filmmakers? Okay, cool. So, if I was to ask you, why do you create the art that you do? What would you tell me?
For fun.
For fun.
It pays the bills.
It pays the bills.
Ooh, self-expression.
Self-expression. Food for the soul. Okay, so if I took all your materials away and I said you cannot create art, how would you feel?
I go batty.
You go batty, right? And the truth of it is that way down we produce the art because we have a need to produce it. There's something inside of us that needs to be expressed. Now, whether we pick it through paint or video graphics or, there's seats up here if you want to come. You can join us, okay? Don't think you have to go back there, but you can join us. But a lot of times also, I'm speaking with this gentleman here, and he was talking a little bit about, sometimes artists don't get a fair rap, right? People look at you and you say you're an artist, though that's what you do in your hobby. What else do you do, right? What's your job? Okay, and it's really hard for some of these people to understand that being an artist is your job. It is a profession, okay? And a lot of it is how you define yourself, right? When somebody says, what do you do? There is nothing wrong with saying, I am an artist. Okay, and until we are proud of what we do, trust me, nobody else is going to give us that respect either. So it really is important that when people ask you, what do you do? Tell them you're an artist. Be proud. It's okay. It's not a bad thing. You know, artists throughout history have played a very important role, number one, in documenting what happens in the world around us. There's a lot that we would not know if it was not for artists who sort of stepped out of their comfort zone and documented what was happening around them. There's a very, very important role that you guys play. Now, the good thing is that the law does not define what art is. The law is not an art critic. It doesn't define what's good, what's bad, what's fair, what's ugly. Okay, it leaves that up to you, the artist. What you guys say is art is what the law will recognize as art. And that is very, very important, right? Because when you put yourself out there and somebody asks you, well, how is that art? What do you answer them? Because you say so, right? There's a very famous artist, Duchamp, who took a latrine, signed his name on it, and said, this is art. And it sold for millions of dollars. Because he said it was art, okay? Which is the other part of the art world, that it's about your reputation. When you create your art represents you. Okay? And that's what you send out into the world, right? Whether you sell it or whether you put it on your website, whether you put it on a business card or a postcard, that art represents you, and that's part of your reputation. I mean, one of your goals is that when somebody sees your artwork, they say, hey, that's Ted's artwork, right? That's a Danielle painting. Okay? That's really what you want them to know, isn't it? That they could recognize that through you. And part of being able to do that, though, is about protecting then the artwork that you create. Now, how many of you have heard of copyright? Okay, how many of you have heard of copyright that were not in my other class? Okay, good. Well, copyright is the laws that we have here in the United States to help protect the value that artists have in their work. And it's actually a bundle of rights. It's not just one right, but there are 5 rights that you have as an artist to your work. The first one is probably the most simple one, right? You have the right to not have somebody else copy your work and say that it is their work. Okay, and we're going to take a look at some cases coming through there. The second right you have is what we call a derivative right. You have a right to take that original that you created and make something else out of it. Okay? So think of it. If you had this wonderful painting that he did, I'm going to use you as an example. It's wrapped up in a whole unit. And then he decides out of this, he's going to take this image, he's going to make a t-shirt. He's going to put it on a t-shirt. I'm sorry. Mm-hmm. He's going to put it on I'm from New York, so I walk around. I'm sorry, Danielle. Right. He's going to put it on a t-shirt. He's going to put it on a mug. He's going to put it on a postcard. He's going to make a poster out of it, okay? He might create some animation, and all of a sudden you see the figures move out from here. All of those things are considered derivative works. And only he, as the artist of the original, has the right to create those derivatives. Now, here's the good thing is, you can sell that right. You can sell that right to somebody else to make a derivative, but you still have the copyrights in the original. Okay? And you can sell different rights to different derivatives to different people. Okay? So if you think of a book, right, and then they sell the rights to a movie, they can also sell the rights to a play. They're not the same rights. That's what's good about this. You can chop them up and make lots of money in different things. But it's the derivative work that also gives us the ability to license our images. Okay, another way of saying a derivative work is to license the image forward. Okay, so there's the copy, there's the derivative. The next one that we have is what we call public display. You have the right to put your artwork up in a gallery, to put your artwork in a website, and to have people see it in public. Okay? Nobody else has that right in your work except for you unless you give it to them. Okay, you can license that right away. You can sell it. And usually when you work with a gallery, you are assigned right from a derivative work. Okay, so that gallery, even though they're showing your artwork, they can't put that image on a t-shirt with the gallery name on it. That would be illegal. Okay, unless you gave them permission. Right? If you gave them permission, then they can put it up there.
Okay, so your art you want an art gallery to put up if it's without permission?
Without your permission.
Okay.
And even when they make the catalog, so they might have, a brochure of their show, you as the artist have the right to control which images they put in that brochure. You might not want all your images there, right? You might just want one signature image. Why? Why wouldn't you want everything in the brochure?
The public want everything to come for. They'll see all your stuff there.
They'll see everything, and technology is so advanced now. In a court of law, they do not accept a photograph as evidence by itself anymore because it's so easy to manipulate, right? And so it's very easy for them to take an image from a brochure and somebody blow it up if they have the right technology and sell those off as posters. Okay, and that again is illegal if they don't have that permission.
Take a breather for 1 second.
Okay, we have to take a breather every 15 minutes. If not, the files get really big because I talk a lot, right? So we got our 3 so far. What are the 3 rights?
Copy.
Okay, when you talk about technology and images being grabbed from the internet and closed, in order for that, it's going to happen. But in order for it, I think it's not be printed. What do you suggest?
There are some things you can do. Some people put very, very low resolution. Some people control the size of the image. You may only look at it as a thumbnail, for example. Some people will put a watermark under it. And if you're really technology savvy, you might even disable the right click on the mouse. And there are ways to do that, but you really need somebody who knows how to sort of work that on your website, and then they can disable that option so people cannot do that. Now, one of the things you have to be aware of, though, is Pinterest. How many of you have heard of Pinterest? Okay, anybody here has a Pinterest board? Okay, well, it's really amazing. Pinterest is now the 3rd most popular social media platform after Facebook and Twitter. It used to be Facebook, Twitter, LinkedIn. Not anymore. Now it is Facebook, Twitter, and Pinterest. But the idea of Pinterest was that you had an electronic bulletin board, and if you visited different websites, you can pin the image, okay, and then put it on your bulletin board. Well, the truth is, you didn't have permission to pin those images. So everybody who was using Pinterest was violating the copyright laws. How bad was it? Well, Pinterest actually hired the legal head from Google to help them with this issue and see if they can get that straightened out. But it is important for you to know that people might be pinning your images. And the important thing about copyright is that there are no copyright police. Okay? If you want to protect your rights as an artist, you have to do it. You have to be vigilant. You have to monitor. Everybody here should, first of all, create what's called a Google alert on your name. Does everybody know what a Google alert is? If you don't, you can Google alert. But what it allows you to do is whatever you put that alert for, it could be your name, it could be the name of your company, right? Because some artists, they'll create companies to protect their personal assets. It could be your genre of art. But then when it's out there on the internet, Google will send you an email every day showing you how it came out. So I always, do a Google alert on my name And the guys from the other class, close your ears. You've heard this joke before, but I am a basketball champion in Mexico. Isn't that cool? I mean, can't you see me just jumping and dribbling, right? But every time I get that Google alert and I see her and I say, yeah, she did that really good, okay? But it is good to know because then you know who's talking about you, right? There might be some art blog that picked up something that they liked and they're using your image, but they never got permission to use your image, okay? And some art blogs are wonderful, right? They have good reputation. But then there are other art blogs that you might not want to be associated with. And so you need to monitor that. Where are you appearing out there on the internet, okay? Now this gets connected with what is called a public performance right. A little bit different from the public display. Display is just out there. Performance is more that something has to be done. And when it comes to website and cache and all of that technology stuff, this is where that right falls into. Okay, public performance falls into the website in there. So there's the display, the performance, the derivative, the reproduce, which is a copy. The last one is called the right to distribution. Okay? And that's the right for you to sell your work. That's the right for you to give your work to a charity if you choose to. Okay? So that right to distribution is part of that bundle of rights. Okay. So I have an example here on page 3 of your handout of that derivative right. Yes? Is there anybody else who doesn't have a handout? Hand those back there. Wonderful. And this is a very famous artist. His name is Jeff Koons. Have any of you heard of Jeff Koons? Okay, I'm from New York. We know about Jeff Koons in New York. Jeff Koons makes gigantic puppies in pink and white and puts them all over New York, okay? And when you see this gentleman, you really don't think that he would be the kind to make puppies. But he does. So there was this photo that he found, and it's this couple, and they have a whole bunch of puppies there, and he thought it was really nice, and he made the sculpture of that photo. Okay? And the photographer of the photo sued him, saying that this was a derivative work, and he did not have permission to make that sculpture off of his photograph. Derivative is that you can make something from the original, right? So he said, I can make the sculpture from the photograph, but he couldn't, right? Because the photograph wasn't his. The court says you could have done it if it made it transformative enough. If the derivative was transformative, in other words, that it created something completely new, then it would have been okay. But the court said all you did was change the photograph to a sculpture. There was nothing new. Okay? So how does this work? Well, I had somebody right here in Binders one time tell me, well, I found all these wonderful photos on the internet and I'm just, making paintings of them. Is that okay? What do you think? No, because isn't he doing what Jeff Koons did, right? Even though you say, but that's a photograph and this is a painting, wouldn't that be transformative enough? The court would say no, that it is just an exact copy in a different medium. Yes?
So what is transformative?
What is transformative? I'll give you an example of one that I'm not exactly agree to it, but it sort of gives you the sense of what the courts are thinking. How many of you know who Tiger Woods is?
Tiger Woods.
You're laughing and you don't even know what I'm going to say, For most people, when Tiger Woods came along, he was young. Do we need to stop? Are we okay?
No,
okay. He was young, and he really got the younger generation sort of interested in golf, right? So for many people, Tiger Woods became associated with golf. He wasn't just a player, he was golf. And so we had an artist who did representations of athletes. And he did a painting that he called The Spirit of Golf. And it had Tiger Woods facing forward and facing this way with his golf club and then facing the other way with the golf club. But you can tell it is Tiger Woods, okay? 3 images facing that way. And it was called The Spirit of Golf. Well, Tiger Woods sued for publicity rights, saying, well, that's my image. I make money off my image. You don't have permission to use it. The court said that the use of his image was transformative, that it wasn't an image of Tiger Woods, but an image of golf. You don't get it, right? That's the problem, is that when the court gets involved, because they are not artists, they look at the issue of transformative not as a creative element. They look at it more as technical.
Why would it be Tiger Woods who had graciously rather than the artist whatever pictures the artist made?
It wasn't based on a photo. It was just based on Tiger Woods. It depends how good an argument you can make of how transformative it is. Okay? And this is why it's so hard, right? Because when you guys create, do you create in a vacuum? No, right? You are getting input from all over the world every day, things that you see, right? The people that you interact with, whether it's television, whether it's radio, whether it's the music, whether it's, coming into binders and being inspired by all the things that are here, okay? And so you're going to come up with some images that may look very much like other images that are around. And that's why your story to your art is so important, okay? I was asking a couple of you, what's your theme, right? What does this mean? When you are doing your art, what is your message? Because that helps convey whether it's transformative, whether it's original enough, because it's about how you thought about it. What creative decisions did you make to come up with that image? Photographers have this problem all the time. Anybody here do photography? Okay. And people will say, well, all you do is snap a picture. Right? What's the artistry in that? How much work is there? Photographers have taught me about the issue of light. How do you see light? Especially through shadow. I happen to love black and white photos. I think that they're just so dramatic. It takes a lot to get the right composition. Okay? And how does that play out in the real world? I'll give you an example. Weddings. People believe that, give them a camera, you can take a wedding photo, and it'll be fine. And I have dealt with weddings. You just, no, that doesn't happen that way, does it, right? You're taking about 400 photos to get that one photo that then they can, put up there. But it does take a lot. And every decision that photographer makes to move the camera, to put the reflector up, to move somebody this way or that way, okay? When you make a painting, what size of the brush that you use, whether you use a knife to do a certain element to it, whether you're using canvas or cardboard or paper stock, all of those decisions go into the whole act of creation of your art. It's not just your final product, okay? We're still good? Okay. Now, copyright is automatic. Isn't that cool? It means as soon as I do my art, it is protected under the copyright law. Okay? The laws do not say I have to run out and register it right away. We do not even, right? You're not even required to do that anymore. You don't need to put that C in a circle anymore because it is automatic. Okay? Now, saying that, if you want to enforce your rights in a court of law because somebody copied you, guess what you have to do? You got to register. Okay? The law says in order to get into the court, you have to register the copyright. Now, one of the good things is, though, that copyright is fairly easy. Most of you can do it right on your own, right online, and it costs about $35. If you go to the Copyright Office, they have these wonderful little brochures, and I'm going to pass this around so you can see. This one is called Copyright Registration for Works of Visual Arts, and they have all different kinds. So even if you did music and needed to record sound recordings, they have special brochures for that. And they go and step you through the process of registering your artwork. Now, a couple of questions always come up when we talk about registration. Okay? Now, I told you that in order to protect your rights, you have to register it in order to be able to go into a court of law. What do you think you can get if somebody copied your art? Not much. What do you want to get when somebody copies your art?
Some money.
Some money, right?
Some
Is it
revenge.
just money? What else? Some revenge. Okay. Whenever I get a client who says it's the principle of the thing, I give them a really high retainer. Okay? Because let me tell you, don't go into a lawsuit because it's the principle of the thing. Okay? Lawsuits are long. They cost money. They cost relationships. They cost a lot on your life. Okay? So I always like to leave lawsuits and litigation for the very end. A lot of times we can talk our way out of some of these things. Okay? But what does the law say? The law says that if somebody copies your work, you are entitled to get any of the profit that they make. Okay? Now, profit is different from revenue. Right? Revenue is money that they actually got. So let's say, okay, the binder's t-shirt, right? Here. This little image back here. Did anybody here make this image? No? Well, we got to change that, don't we? We got to get them to use one of our images here on this. But let's just say this was an artist, okay? And binders, by mistake, not that binders would do this, but let's just say binders, somebody here, an intern, didn't know what they were doing, put the image, put it on the t-shirt, and then sold the t-shirt for $10. Okay? The artist finds out about it and says, hey, that's not allowed, right? I didn't give you permission for that. And the artist says, okay, I want your profit. Well, let's see. We sold 10 t-shirts, so 10 times 10 is how much? $100, right? But that's revenue. Now I'm going to start subtracting. Well, maybe, it cost me money to make the t-shirt. $5 each t-shirt. So now that's $50 out. Right? So now I'm down to $50. Well, it cost me money to put it on the website, and it cost me money to make flyers, and it cost me this. And actually, when I count everything in, I'm like $300 in the hole for those t-shirts. You owe me, right? That is what we call creative accounting. And the reason why so many times going through litigation is not really worth the money, because you're not going to get that back. Okay? You're not going to get that back. Now, the law has an alternative, understanding that that's very difficult to calculate, right? Profit. The law has an alternative. The law says that if you register within 3 months, then you can ask for statutory damages. And statutory damages, listen to this, guys, can be from $750 to $30,000 an instant. 10 t-shirts, 10 instances. $30,000 each one, $300,000. Big difference, isn't it? right? But you have to register within those 3 months. Now, here's the problem. Yes?
You work for your work.
With the Copyright Office, yeah.
So what if you find something, you work for your work?
Well, it's 3 months from publication, not from creation. And let me explain the difference, okay? Because you can create something and never show it to anybody ever. Okay? If I was to go, you guys probably have your homes, your studios. How prolific are you in creating art? You have them stacked up all over the house, right? You give them away as gifts to the family. The family is now saying, no more. Don't give us any more. But you just keep creating, right? And you just keep giving those things away. Okay, and the problem is, do I need to register all of them? That can get expensive, right? If I'm producing 100 pieces every month, at $35, that's $3,500 every month. I don't want to put that in. That's more than my canvas. That's more than my paint. That's more than my, my software. That really doesn't pay out for me. And so you have to ask yourself, what is important to register? You can't register everything. But what do you think would be important to register?
Stuff that you know you're going to sell and make a profit from?
More than just what you're going to sell.
My logo, and I got it on there.
Trademark.
A logo, a trademark. Why would you register it? Anything that's going to get a lot of exposure, right? So if you're in a gallery show and that image is going in the catalog, that needs to be registered because everybody's going to see it. Okay? If you're on your website, are we getting close? If you're on your website and you've got a main image on your website when people get there, that image needs to be registered. Okay? So what we're really talking about are what are your signature pieces? What are those things that you will use over and over again so that it identifies you? It helps create your brand. Okay? Yes? It wouldn't be with the Copyright Office, okay? It would be a contract dispute, provided that you have a contract, and this is something very important for graphic designers, but also for artists if you do a commissioned work. If somebody, says, I want you to do so, they come and they see, this fabulous piece of artwork right over here. And they talk with this gentleman and they say, you know what, Jason, I want you... I'll show that. Okay. I want you, Jason, to do this. I want you to put my dad's face in there. Okay? And so it's a commissioned piece. It's a personalized piece. And there are some issues that come up with that, right? What if I don't like the way he portrays my dad? Do I still have to pay him?
No.
Maybe not. Because it's a personal service, the customer has a right to personal satisfaction. Oh, yeah. How do you define personal satisfaction, right? That could be really difficult. And so the idea of contracts in this way are very important because you can outline in the contract, you will accept this once it's finished, period. Okay? No personal satisfaction. You paid me for this. The other thing is whenever you do a job, get into the habit of asking for a deposit. Okay? And then get into the habit that deposit may be the only money you ever see from that person. So make sure that the deposit is worth it if you never see another dime from them. Okay? You have to find out, well, do I have a contract with that person? And the contract could be an oral contract, right? How many times have you said, oh, yeah, I'll do this for you. You shake on it or, you high five. And yeah, we're going to do this, right? That could be a contract. Now, you're going to have a big dispute over he said, she said, he said, she said, those kinds of things. So you really have to start getting used to having things in writing. Okay, in writing. Now, When it comes to graphic designs and logos, it is expected that once you finish that logo, you are going to assign those rights to that company or individual because that's what you're creating it for, right? So make sure also that you're getting value for giving that to them, okay? Now, you can send them a cease and desist letter, and sometimes this is a great strategy if you don't want to go to court, if you don't want to get, an attorney involved. A cease and desist letter basically lets the person know, hey, I own the copyrights to this, you are using it without my permission, stop, or I will contact my attorney, okay? But you do have to make that step. Okay. You do need to take that step, okay? So if you're doing anything that's going to be corporate-wise, contracts are really, really important. Yes, there is. Good question. Statute of limitations is a certain amount of time that the court says, hey, if you don't do it within this amount of time, it's over. For copyright, that's 3 years, even though there's nothing that's really set in stone. But the law says, hey, you have to be reasonable about this, right? If you wait 20 years and you knew this person was using it for 20 years, we're not going to go after him. Come on, after 20 years, you basically told him, go and use it, okay? Depending on whether it's fraud, under fraud, you can have up to 7 years in Georgia. If it's just a plain contract dispute where there was no fraud, it's up to 5 years. Okay? But you do want to keep that in mind. But don't let time pass. I mean, if somebody took advantage of you, if somebody's using your work, lots of times a cease and desist letter really quick, they get scared. Nobody wants to go, to court. Really, they don't. Another good resource for all of you to know about is the Georgia Lawyers for the Arts. Anybody here ever heard of them? Okay, they're good. They are a sliding scale, so it's not guaranteed that it's all pro bono. I'm one of their attorneys that work on some of the cases there, but depending on your income, sometimes they can do a cease and desist letter for you for relatively little money. Okay, so make sure you know about the Georgia Lawyers for the Arts, because that's always good in that. Okay? Okay. So, and all I did was tell you about your rights. We haven't done anything else, right? But the big thing is now that I know what my rights are, what happens if I find out somebody's copied me? Because remember, the only way you're going to find out if somebody copied you is if you see them, right? Or if somebody who knows you sees them and then lets you know. Okay, but there is no, just because you register with the Copyright Office doesn't mean that they are now out there looking and seeing if anybody's copying your work. They just don't have the resources for it, okay? So once you find out, let's say, you look at a website, you say, hey, that looks really familiar. And then you say, hey, it's so familiar because it's mine. I did it, okay? Document the information. What was the website? Print out a screen capture so that you have it date stamped of when you see it. Because, lots of things online, once they hear about it, what happens? They'll take it off, right? They'll take it off really quick. But if you have that date stamp, now you have proof that on this date, at this time, your work was on their website, okay? This can happen in a chat room. This can happen on Facebook. There's all places that they can have your work there. If it's in a gallery, you have to find out, well, how did they get it? Go in and ask questions, okay? How did they get that image up there? If they say it's an art representative, say, well, I want to know who that art representative is because I'm the artist. Okay? And let them know that you did not give permission for that artwork to be there. But you have to be the person to make that effort. So document all the information that you can get, okay? If it's big enough issue, make sure that your work is copyrighted. So let's say it might not have been a piece that you copyrighted before, but now you see, they have it on T-shirts, they have it on posters, they have it there, they have it there. It might be worth the $35 to go and register it. You won't be eligible for the statutory damages, cease and desist letter. Okay? It shouldn't just go straight into litigation. There should always be a letter first to go through. And that's because also the courts look favorably if you have sent that letter first, because what it tells the court is that, you know what, you didn't want to waste anybody's time or money. You wanted to be very, sort of the big man, the big person, and sort of give them a chance to make it better. Okay, so it makes you look good by sending that letter out first. If nothing happens, and, they might get the letter, they can do a couple of things. They can disregard it completely. They can get their own attorney that will then give you a call and talk to you or talk to your attorney and, maybe work something out. Or they can just send you back a response and say, it's off, no problem, we're fine. Okay? Another thing that you need to know about in the online world is that if you do see your work up there and it's been illegal, there is something called the takedown notice that you can then send to Facebook or Twitter or YouTube or any of these social media platforms. Okay? And you have that right under the Digital Millennium Copyright Act that says, the DMCA, that says you have a right to send them a notice, tell them that you are the copyright owner, that it is up there without your permission, and that you want them to take it down. You want them to remove it from their server. Okay? And they are obligated then to do two things. Number one, take it down. And number two, inform whoever posted it that you have a complaint about. Okay? And most of these things you can do right online. There's a form in each of these platforms that then you can put up there. Okay. Now, let's say you did the takedown notice, you did the cease and desist, you're getting no response, you notice that they are really racking up the dollars and selling these t-shirts. Then you have a really serious conversation with your attorney and your significant other about whether you're going to go into litigation. Okay? Because it can be a life-changing decision. We already saw that, sometimes there's no money in it. We've had one artist who actually did a Kickstarter campaign to raise $10,000 to pay his legal bills so that he can defend himself for copyright violation, okay? So you really have to think about it. Do I want to do this? Do I want to go ahead and go through this lawsuit with it or not? Okay? And there's a lot to think about in that, right? Most of us do not have thousands and thousands of dollars or a lot of time to spend in this kind of a case, okay? So you need to be vigilant and you need to make those questions. Now, any of you do art that goes to other countries? Okay, and so there are some things as well that you need to keep in mind. There is no such thing as an international copyright. Okay, every country has its own copyright laws. So if you want protection in a particular country, you need to have it registered in that country. We do have a mechanism called the Madrid Protocol that actually allows you to start registration in over 80 countries with only one fee. But then to finish it off, you have to follow up in each country. Not necessarily that you would need that, but if there is a signature piece, again, that is going out there, you want to maybe have some protection. What's good is that the U.S. copyright, although it's not an international copyright, is very well recognized in the rest of the world. So it sort of serves as that first level of evidence for you in that, okay? There is some information in your handout about those things. So let's talk about some other few issues with copyright. Okay. So what is the public domain? Anybody ever hear?
When the statute has expired on copyright, pretty much it's now available for use.
In the beginning, copyright only lasted a certain amount of time, and then you actually had to renew it. Okay? We don't have that requirement anymore, that you have to renew the copyright. If you register, it's registered, or it's automatic. And copyright lasts up to 75 to 95 years above the life of the author. Okay? So once you die, your family still has another 75 to 95 years to make money off of your work. Isn't that cool? Okay. It doesn't always work so well, though. We had a case, Marilyn Monroe. The court just decided that her estate does not have publicity rights. And so that Marilyn Monroe now belongs to the public. And why did they come up with that? Well, publicity rights is based on state law, and it's based on the state that you live in at the time of your death. And Marilyn Monroe's residence was New York. New York does not recognize publicity rights after death.
You know, she died in California and lived in house.
But her residence was New York City. Okay, so it's even important where you die now, right? You got to add that to the list of things that you have to look at in those things.
Company Dakota, Kansas, please.
One thing that goes like with actors and stuff, I noticed that none of them actually stayed in like New York. Like New York and California, people that actually like don't stay. They got property everywhere else, but everything there, like.
Yeah, they just live in hotels in LA, you know, but their residence are someplace else. You wouldn't believe it, but you know the best place to die if you're a celebrity? Indiana. 100 years of publicity rights after your death. Who knew? Indiana. Okay, but Georgia was actually the first state to recognize the publicity rights. Yeah.
Ray Charles. He did a commercial. He had Ray Charles and they are fighting.
Yeah. Bette Midler won a case just to show you how far publicity rights can go. It's not just about the look, it's also about the sound. BMW had a commercial, and they had a singer who sounded just like her because she refused to sing the song. So they got a sound alike, and she sued, saying, you know, that was my sound, even though it wasn't me. And she won the case. The court said, yes, she had a very distinctive sound, and they had hired that person specifically because they sounded like Bette Midler. And so, you know, you got to be careful. You got to be careful who you're doing with. And she's alive. That's the other thing, right? You have much more rights when you're alive than when you're dead in doing that. Okay. Let's talk about appropriation. I've spoken before about, you know, people don't create in a vacuum. And public domain is so important because what that allows is for people to be able to use images that may be familiar, images that have become cultural symbols and icons in their work, okay? And if we didn't have a public domain, it'd be very difficult, right? Because everything would be protected. We wouldn't be allowed to use anything. And appropriation is based on a doctrine called the first sale doctrine here in the United States. And it means that if you buy something, it's yours, right? I buy this notebook, or in this case, it's given to you, right? And so as it's given to you, we own personal property, right? It is yours, and you can do whatever you want with it. You want to rip it up into small little pieces, you can rip it up into small little pieces. Well, that also works the same way with art. Somebody can buy your art and rip it up into small little pieces. Is that what you want them to do with it? No, right? But here in the U.S., that's the property right that people get when they purchase something, and that's what's called the first sale doctrine. Now, this goes against what in Europe they call moral rights of an artist. And moral rights is the right to the integrity of your artwork and the right to attribution. In other words, for you to have your name on that artwork or for you not to have your name on the artwork. Okay? So in European Union, they would not look favorably at somebody who had ripped up that painting into pieces. That person who would have ripped up that painting into pieces would be in jail. Very different from the U.S. where we're saying, hey, it's yours. You bought it. It's yours, okay? We now have what's called the Visual Artists' Rights Act, or VARA, V-A-R-A, Visual Artists' Rights Act. And it's sort of trying to give some of those moral rights to U.S. artists, what they already